The seat of arbitration is arguably the most important decision when forming an arbitration agreement. It is important to emphasise that the seat is not the geographical location of the arbitral hearing, but a legal construct. It is the location where the arbitration has its formal legal jurisdiction and the place where the final arbitral award will be made. It plays a very important role in the legal framework of international commercial arbitration and has a number of vital implications. I'm going to highlight these using an example agreement between a US and British company to arbitrate a dispute regarding the international sale of goods, according to the ICCA rules seated in Sydney. The British company will seek to enforce this award in the UK. Turning firstly to the arbitration agreement. The parties have the autonomy to agree on a seat. They will endeavour to choose a neutral forum where neither party has strong ties, as neutrality is a key feature of arbitration. In the example, the US and British company have selected a neutral seat of Sydney. The parties are not required, however, to incorporate the seat into their agreement. Where parties agree to institutional arbitration, the institutional rules provide a mechanism for selecting the seat. For our example, the ICCA rules Article 23.1 provide without election, the seat will be Sydney if the parties cannot agree on a seat within 15 days of commencing arbitration. After selecting the seat in these early stages of the legal framework, the importance of the seat becomes more apparent. In practice, the factors I am about to explain will have a strong impact on which seat the parties choose. I will start by explaining the role the seat plays at the national level. The seat determines the lex arbitri, that is, the procedural law that will govern the arbitration. The lex arbitri provides the basis for a number of procedural matters, including requirements of the arbitration agreement, the composition of the arbitral tribunal, the conduct of the proceedings, and the making of an award. For our example, this is the International Arbitration Act 1974 Commonwealth, which enacts the UNCITRAL model law. One specific area which I would like to focus on is recourse against an award. Under Article 34 of the model law, recourse is limited to procedural matters, including incapacity of a party and an invalid agreement. If the seat were the UK, however, under the Arbitration Act 1996 UK Section 69, arbitral awards can be set aside or annulled on points of law. This is a clear example how the selection of the seat influences the procedural law applicable and the different outcomes that are possible as a result. The seat also determines which national courts will have supervisory authority over the arbitration. It is important to choose a seat that has a national framework and courts that are supportive of international arbitration. Australian courts have consistently demonstrated their support, like in TCL Air Conditioner and Castel Electronics, where the federal court refused to set aside an award unless real unfairness or true practical injustice in the conduct of proceedings can be demonstrated. The International Arbitration Act also limits the scope of the court's power to intervene in accordance with the New York Convention. After an award is made by the tribunal under this national framework, the award must be enforceable internationally under the New York Convention. The seat is essential to determining whether the Convention can apply. Article 1, Paragraph 1 provides that the Convention applies to awards made in the territory of a foreign state. As I have explained, the final arbitral award is made in the seat, meaning it is vital to choose a seat that is a signatory to the Convention so that the award may be enforced under Article 3. In our example, an award would be enforceable in the UK, as both Australia and the UK are signatories. As the Convention applies to our arbitration, there are some limits that exist on the enforcement of an award. Under Article 5, Paragraph 1d, enforcement of an arbitral award under the Convention is dependent on the arbitration being in accordance with the law of the country where the arbitration took place. The type of matters which are arbitrable, and therefore in accordance with the law of the country, will vary depending on the seat chosen. For our chosen seat of Australia, matters which are not arbitrable include criminal law matters, taxation matters, and matrimonial matters. International sale of goods disputes are arbitrable, and therefore this award is enforceable. I hope this video has given you a basic understanding of the role the seat plays in the legal framework of international arbitration and showed how the decision made by the parties could wildly impact the procedure and outcome.